the alternative dispute resolution process is something that has been used extensively, not only here, but across the country with most regulatory bodies and organizations. Generally, it's set out in legislation, and we're going to talk about that. But before we go down that road, I want to talk a little bit about what exactly do we mean when we're talking about alternative dispute resolutions. And you can follow along on the slides here. So when we're talking about ADR from our end, we're talking about a process to resolve a dispute with the consent of the parties without a determination by the Complaints Authorization Committee or a discipline hearing. And I will say as well that this is an area that is evolving in terms of the buzz and the lingo these days as well. So some of you, if you're keeping abreast of current trends in the ADR world, will know that the new buzzword out there these days is not alternative but appropriate dispute resolution. So the landscape is changing in terms of the terminology that's being used as well. The other thing that I will point out to you is that for most people who talk about the ADR process and really what do we mean when we're talking about ADR, traditionally, and for most areas of practice out there where ADR is used, it's often thought about in a very traditional sense. And when I say that, I'm talking about, for most people who think about ADR, they think about negotiation, mediation, arbitration. So that's sort of the traditional types of areas that we talk about when we're talking about ADR. We consider the ADR process in the Registered Nurses Act to be a little bit different than that. So we don't follow the traditional sort of lines of authority in the ADR world. And the reason being is that our ADR process is legislated. So for example, we would not engage in an arbitration process to resolve a dispute and to use that as an alternate dispute mechanism. The reason being is that we have a process that's specifically legislated in terms of how our disputes must evolve. And that would be through the Complaints Authorization Committee, for example, if a resolution cannot be facilitated, or a discipline hearing. So we wouldn't be in a circumstance where someone or some authority or body or individual other than a Complaints Authorization Committee or a discipline hearing, an adjudication tribunal would be making a determination of whether someone is engaged in conduct deserving of sanction. So I point that out to you because in the ADR world, that is the general trend sort of as things move to escalate up along negotiation, mediation, and arbitration. So when we're talking about alternative dispute resolution, we're really talking about a mechanism by way of an agreement to resolve an allegation. And ARNL's authority for that comes specifically from our legislation, the Registered Nurses Act. And in fact, the Act under Section 22(1) specifically provides the Director of Professional Conduct Review with the authority to resolve an allegation. So that is specifically giving Michelle Osmond, in this case, the ability to attempt to resolve an allegation that comes before her. Provided, however, that that is with the consent of both the complainant and the respondent. Under Section 22, Michelle would have no ability to attempt to resolve an allegation if, for example, the complainant is not agreeing to resolve, or the respondent, the registrant, is not agreeing to resolve. In those circumstances, Michelle would have no authority and would actually have to refer the allegation on to the Complaints Authorization Committee. Now, Section 23 of the Act also gives the Complaints Authorization Committee the authority to actually refer the allegation back to the Director of Professional Conduct Review to consider ADR as well and to explore ADR. And you might ask yourself, well, in what circumstances would that happen? Because If the director already had the ability to do that under Section 22, and for some reason it's ended up before the CAC, what would cause the CAC to actually refer it back to the director to explore ADR? And I'll just give you a scenario so you can appreciate exactly what we're talking about here. Over the years, there have been a number of complaints where the complainant themselves have refused to do ADR at the onset and have specifically requested that the matter be referred to the Complaints Authorization Committee. So they weren't prepared in the circumstances giving rise to the allegation to attempt to resolve by way of alternate dispute resolution. And it was circumstances quite often that Michelle, in her role as director, would have considered to do ADR on, because it would have been an allegation that would have been of the nature and appropriate for alternate dispute resolution. But without the consent of the complainant, she couldn't do that. And so when it's gone to the Complaints Authorization Committee, the Complaints Authorization Committee may have looked at it and said, this could be something that could be resolved through ADR, and has directed Michelle to go back to the complainant to ask the complainant to explore, would they be prepared now that the eyes of the CAC has been on this, and the CAC has said this would be an appropriate type of allegation, to go back and explore that possibility. And we've had that happen a handful of times, and it's worked well. We've had circumstances where the complainant, once they've recognized that the CAC is also seeing this and are giving it this type of lens, that they'll look at it and say, okay, now that the CAC has looked at this, I'm prepared to explore what you have in mind here, how you would look at attempting to resolve this allegation, and that has worked well, and we have been able over the years to facilitate resolution with the complainant in those matters where ADR was originally not being explored. The other circumstance from time to time when the allegation has been referred by the director onto the Complaints Authorization Committee is the nature of the allegation may be such that the director doesn't have a comfort level with attempting to resolve without further direction from the Complaints Authorization Committee, for their eyes to see it and for them to say, yes, we would consider that this would be appropriate for ADR and to send it back, because sometimes you're dealing with matters that are, there's some grayness to it, there's no doubt, and whether or not it would be appropriate to do ADR. So again, that extra set of eyes, that extra lens, that the individuals ultimately tasked with protecting the public here, the Complaints Authorization Committee and counsel and the adjudication tribunal, you know, those are the levels that really are ultimately responsible for decision making. From there, we have Section 16 of the Registered Nurses Regulations, and that provides the director, again, with the authority to pursue ADR. And under that piece of what we call subordinate legislation, our regulations, that legislation actually sets out and requires that both the complainant and the respondent, if they're going to consent here, must consent in writing. And again, it must be something that the director would consider suitable for alternate dispute resolution. The regulations also identify that the ADR process must be conducted in accordance with the policy that's established by counsel. And counsel actually has a policy statement that specifically sets out the procedures for the director to follow when embarking on ADR. So I'm going to just take a moment and turn this back to Michelle, and she's going to speak to the counsel policy.
Yes, as Trudy said, counsel does have a policy for ADR, and they were required to establish this policy under the regulations. And for any of you who are handy at your computer, you can look at the policy on ADR at any time. It's on ARNML's website under the Complaints and Discipline page. And I'm not going to read all of the policy, because if you're looking at it now, you'll see there's quite a number of steps, or if you will, criteria under the policy. But I'll just read to you the policy statement, because this is a nice lead into the next slide that we're going to have presented this afternoon. And this is to the Complaints Authorization Committee, following referral of an allegation to the CAC, that's Complaints Authorization Committee, by the Director of Professional Conduct Review, may refer the allegation back to the Director of Professional Conduct Review for alternative dispute resolution. An ADR is an agreement process to resolve allegations filed against the respondent, so that's the registered nurse or nurse who has the allegation made against them. Any ADR must be in compliance with maintaining public protection pursuant to Section 4 of the Registered Nurses Act, and Section 4 is the object or the mandate of the association. ADR shall be agreed upon by the complainant, respondent, and ARNML. And I will tell you, this is the policy statement that Council established in accordance with the regulations. This policy statement, when the CAC orders an ADR from their review of an allegation, this actual policy statement is provided to both the respondent and to the complainant when I write to them and ask for their consent if they're willing to pursue or explore ADR for the resolution of the allegation. The other thing that I will tell you about this policy statement, although it's specific to the Complaints Authorization Committee, so Section 23, when the CAC directs ADR, this same policy is put to the process that that I would use when I'm doing an agreement under Section 22 of the Act. The same thing, I would look for consent of both parties. It has to be in the interest of the public. So the same type of information, the same steps or procedure holds true for both processes.
Okay, so Michelle, reading that policy, the lead-in to the procedure there, the policy statement itself, reference section of the Registered Nurses Act. So the overriding mandate in the ADR process is protection of the public. So going back to the original slide where I talked about the traditional process involving, from ADR perspective, involving, negotiation, mediation, arbitration, that would not work in our circumstances, because often when we're talking about strict ADR, it's getting the parties together to come to some agreement. And while the parties may agree in some circumstances, the association may not agree because of this protection of the public element that is the overriding mandate of the legislation. And that is why the association then becomes part of this agreement process, because that is the overriding mandate and the overriding object of the Act. And that's significant because there's a whole body of case law out there, both from our courts here in Newfoundland, but also the Supreme Court of Canada. And the Supreme Court of Canada has reviewed decisions of regulatory bodies such as ourselves on numerous occasions, and there's a number of cases out there where the Supreme Court of Canada has said that regulatory bodies play a very crucial role in protecting the public. And those cases go on to talk about what happens if the regulatory bodies fail to do so. And of course, the risk there is that the profession loses its right to self-regulate. And if you watch on this, follow the news, you will see in the past number of years, there have been circumstances where regulatory bodies, both in Canada and across the world internationally, have had either their regulatory privileges totally revoked, or governments have put in place some oversight boards to ensure that the process is functioning and the public is being protected as it should. So that is why whatever we do, the umbrella and the mandate for our whole process has to be the focus of public protection. So what types of allegations can be resolved through ADR? So any of you who are familiar with our Act, specifically Section 18 Act, you will see that what I've produced here is actually directly from Section 18 that identifies what is conduct deserving of sanction. And that would be professional misconduct, professional incompetence, conduct on becoming a registered nurse, incapacity or unfitness to engage in the practice of acting in breach of the Act, regs, the Code of Ethics. So any of those types or categories, I should say, of misconduct or conduct deserving of sanction could be open to be resolved through ADR. The question comes, on what scale is that professional misconduct, for example? So you have to look at the nature of the allegation. So, for example, there's a broad range of, if we look at the continuum, for example, of, let's take professional misconduct. Just use this as an example. Let's take that someone accesses their own medical chart on one occasion. That may be something that can be resolved through ADR. However, if it's a circumstance where the individual has accessed hundreds of patient charts, well, that's not going to be something that's open to ADR, because the types of sanctions that would need to be put in place in those types of circumstances would not be conducive to ADR. So when you're thinking about the ADR process and the types of allegations, I think it's fair to look at it as a continuum in terms of, you know, things that are less serious to things that are more serious. Not to say that we done things and resolve matters that are serious, provided that the appropriate types of terms and conditions and restrictions put in place with, again, that mandate of protecting the public being the ultimate goal here. So that leads to the next question as to process, and in this continuum, what are the factors guiding the ADR process? And Michelle has a great deal of involvement at this level in terms of working with complainants and respondents to look at and explore those terms and conditions. So I'm going to pass it back to Michelle at this point.
Thank you, Trudy. So we have here prepared some of the factors guiding in the ADR process. And the first one there, as Trudy stated, of course, the overriding consideration when looking at whether or not it's appropriate to do ADR is public protection. And so on receipt and review of an allegation, I will consider the conduct, whether it's competency issues, conduct, fitness, what is set out in the allegation. So remembering those 5 areas that Trudy mentioned, that conduct is deserving of sanction is set out in our Act. And in this review, I will, I guess, identify, or knowing the terms, conditions, restrictions available, or others that may be identified in situations where perhaps a particular conduct hasn't previously been before ARNL. And it has to be that any of those terms and conditions or restrictions that would be put in place as part of an ADR must protect the public. If I'm not, you know, in that review able to identify or anything that we would put in place, it's still not protecting the public, then it's not going to be resolved through ADR, and it's going to be referred to the committee. Also, Trudy referenced the legislation, both in our Section 22 and also the Section 16 of the regulations that requires for ADR to proceed to even explore what could possibly be a resolution or in an agreement, we have to have the consent of both the respondent and the complainant. And we do have to have that in writing, or it can be electronic under policy. For for ADR, with respect to the respondent or the registered nurse, to pursue ADR, the nurse must acknowledge that what is alleged in the allegation is valid. So they are acknowledging, yes, what this complainant has put forward is valid. If you want to put it in another way, the nurse will be saying, yes, I did it, or I didn't do it, depending on what the situation is. But if the nurse's position is, no, this didn't happen, what they have alleged here, I didn't do, then that is not something that I can pursue ADR with. I will have to refer to the committee because I'm going to need to, we're going to need to investigate that and get more information. So it does require the nurse to acknowledge that what is been alleged is valid. And further to that, I would say that if it's a situation where the allegation has multiple issues in it, so multiple circumstances where the nurse, there's an allegation of conduct deserving of sanction. So, you know, there's medication errors, there's failure to document, there was procedures were done incorrectly. Let's say there's multiple things. In proceeding with ADR, it's all of those things that the nurse is agreeing is valid. It's not, I did A and B, but I didn't do C. When we do ADR, it is one package. We don't pull out items to say, you know, okay, well, you didn't do that. It is the full allegation that is being resolved. In terms of accountability of the registered nurse, we certainly see where a registered nurse has accepted accountability for what occurred, particularly in situations where it's occurred within an employment setting, and the employer has already done their own follow-up to it, and they've met with the nurse, and she's or he's agreed that, yes, you know, what's occurred, I'm accountable for this. We certainly see that that can have a positive effect on the ADR process in that the complainant is likely to agree that, yes, we'll pursue ADR here because they already seen that the nurse has taken accountability for what has occurred. The other thing that we have also seen from time to time is that in, taking that accountability, a registered nurse may already have commenced some reflection on what occurred, or even, sought out some resources to address what occurred from a learning perspective. And certainly when we see that level of accountability, it certainly does speak positively, as a factor for guiding the ADR process. The final factor that we have listed here is whether there's sufficient information to craft an appropriate resolution. As Director of Professional Conduct Review, I don't have the authority to go ahead and commence an investigation. I can ask questions and I get some information, of course, in speaking with the registrant or the complainant. But if it's a circumstance where you need to get into whether it be most likely be client records or documentation recorded with respect to a patient or a client, I wouldn't be requesting that without authorization that an investigation is to take place. And sometimes when we receive the letter of allegation, that is the total of what I receive, a letter that states on such and such a date, this is what occurred. So there is not additional documents attached to give more information. So it can leave me with questions. And in order to know what terms and conditions or such as, remedial that will be part of an ADR, I need more information. So that will be something that is referred to the Complaints Authorization Committee. Trudy, I don't know if you had a comment there.
The only other comment that I'll make in terms of some of the factors, from time to time, we'll have a circumstance where the employer is the complainant, and it's a circumstance where, as part of this whole process, the registrant has been terminated from employment. And the question arises from time to time in those circumstances, is it possible to still do ADR in circumstances where the employer is the complainant and they have terminated the registrant? And the answer to that is yes. From time, our employers will not engage in that process. However, it is doable. We've had circumstances where an agreement can be crafted in a way that protects the rights of both the complainant and the respondent with respect to any other processes. For example, if there's arbitration processes or other civil processes that are engaged, that this is specific to this particular proceeding and is not to be used in any other process, basically. And there have been employers have engaged in the process with that type of language placed in the agreement. So I just put that out there because the question does come up from time to time.
Thank you, Trudy. Just moving on to the next slide now. Again, as Trudy said, with respect to resolving under Section 22, which gives the Director of Professional Conduct Review authority to do an ADR, an agreement process, and the language in the Act is, where it appears it could be satisfactory resolved. So that's where I would be looking at it to see that ADR is appropriate, or can we proceed with that? And some of the things that I would be looking at would be certainly the seriousness of the allegation. And I mean, there certainly can be circumstances where the nature of the allegation is of such a serious nature that it does require review by the Complaints Authorization Committee. And this could include examples, with conduct or with practice, such as in practice significant patient harm or death, or an allegation comes in with a large volume of number of issues. Trudy gave an example of, a large number of privacy breaches, accessing patient records. Serious competency issues that include or go across a number of nursing practice areas, and or information in the allegation suggests that there was, disregard of standards and policies, or the employer has attempted or has worked with a registered nurse to address deficit areas or areas in the nurse's practice that were not up to standard, and it hasn't been effective. So we've seen that from time to time, that there's been a number of remedial type of efforts out in the employment setting, and it hasn't been effective. So when that sort of circumstance comes in, it's serious nature, so it would likely get referred to the Complaints Authorization Committee. Repeat offenders, circumstances where we have already had a nurse before the association and with a practice issue or a conduct issue, and that has already been addressed through an ADR process. So the nurse has gone through remedial, has had a period of monitoring by an employer or through the practice setting, and they're back at the ARNL again with similar circumstances, or sometimes different circumstances. But again, it does cause you to reflect on, is ADR the process to go through when we're not long after having resolved something with this individual. There are certainly conduct and practice issues that occur that suspension or revocation, indefinite suspension, is certainly something that you see as a sanction. But as Director of Professional Conduct Review, I have no authority to suspend a nurse or to take a nurse's license. That is something that has to go through the process through the CAC and then to an adjudication tribunal. under the legislation, there's two circumstances where a nurse's license could be suspended. And those circumstances are, when I say circumstances, I mean by two authorities. One is by council, and that would be an interim suspension at the recommendation of the Complaints Authorization Committee prior to a hearing before the disciplinary panel. And the second circumstance is through the an adjudication tribunal of the disciplinary panel. They have the authority to suspend a license. General deterrence. We are a profession. We have many registrants or members, if you will, and there is conduct or practice that occurs that a message needs to go out to the profession to let them know if you're engaging in this type of practice or in this type of conduct, you know, it is something that is sanctionable and a sanction will be issued. It is conduct deserving of sanction. So it does provide a general deterrence to the profession because it goes through the process up to the disciplinary hearing and a sanction is issued. And as you know, since 2008, under the Registered Nurses Act, where the adjudication tribunal sanctions a nurse, such as suspending or putting ongoing conditions on the license or practice of a registered nurse, that information does become public and is published in a newspaper, and you would be familiar as well as seeing a summary of those decisions in ARNL's Access magazine and on the website. So the information is put out there to all members of the profession and certainly as general deterrence. And certainly one other consideration is, are we seeing a pattern of conduct here versus a one-time incident? And having said that, certainly there has been circumstances where we have had ADR for a one-time incident, but sometimes it also can depends on the circumstances and the context, that something of a one-time nature could also be referred to the Complaints Authorization Committee. Trudy, did you have anything to add to that one?
No, I think you covered everything.
Okay, so I just want to provide you with some sample terms and conditions or restrictions that may be part of an alternative dispute resolution agreement. Many times, and in most cases, there will be remedial education because what has occurred, we have identified that there is a deficit or a gap in the nurse's knowledge. So they could have to do specific courses. Certainly the Code of Ethics for registered nurses is one that many agreements, that there would be a portion of the agreement require them to do the modules. And as you know, they're online, available, developed by CNA and available through Course Park. Practice NL, the jurisprudence module. I got jurisdiction there, but I should have jurisprudence. And so that module is available to any registered nurse in the province, and those are the rules, the legislation and the rules governing practice of registered nurses in Newfoundland and Labrador. So that provides an overview for the person completing the module. What are the rules and what do you need to know about the Registered Nurses Act regulations, ARNL bylaws, and other pieces of legislation to practice in the province. To complete a reflection paper, so the nurse is asked to put in writing, in response to what occurred, what the conduct was, reflect on that in terms of the standards of practice, registered nurses, and also the Code of Ethics for registered nurses, and how they would approach the situation if it should reoccur, and what they did learn. And from time to time, there might be other ARNL documents required as part of that reflection. So for example, if there was a failure to document care, for example, that was part of the allegation, ARNL documentation standards would be something that a review would be required of. And as you know, ARNL has a number of interpretive documents or regulatory documents. Any of these could be part of an ADR depending on the particular conduct. And there is a requirement to meet with an ARNL practice consultant following the completion of the reflection paper, so that there's an opportunity to take that reflection from a paper to a discussion, and to have an opportunity through the practice consultant to really consolidate the learning and having to articulate it, again, going back to the standards and the code of ethics or the appropriate ARNL document. In matters where there is fitness issues, fitness to practice issues, the agreement will require reports from the respondent's healthcare provider, monitoring reports from a supervisor, the nurse's manager, and that can occur actually in across a number of areas of conduct deserving of sanction, whether it's competence, but also if somebody is returning to work from a fitness, a wellness situation, we want to know that the person is, going back to practice and, doing well in their practice as they go back. Random drug and alcohol screens, of course, again, a fitness issue. If we're resolving a matter where a nurse has an addictions or a substance use issue, there will be a requirement for random screening. Restriction on a license, depending on what the circumstances are that brought about the allegation. A nurse may be, for a period of time, prohibited from practicing in a specific area, for example. And that may be linked to having to do coursework and also having to have a period of monitoring. So, in order to get monitoring, you need to be working with other nurses, with somebody who can provide you oversight, like a manager, versus some of our practice areas are very autonomous. And, you're going into a client's home, for example. There's nobody directly with you to oversee you in your practice setting. And then, of course, notification to an employer. And that circumstance takes place where the allegation comes in from somebody other than the nurse's employer, whether that be a member of the public or another registered nurse. ARNL will notify the employer that there is an allegation, and also the nurse, as part of the agreement, will have to provide the employer with a copy of the ADR of the agreement. And of course, if the nurse leaves our jurisdiction to get licensure outside of Newfoundland and Labrador, if the agreement is still working its way through the terms and conditions, that other regulatory body, when we issue a verification of registration, will be notified of the ADR and the contents of the ADR. So timelines. There is nothing in the ARNL Act, the Registered Nurses Act, or the regulations that says, an ADR has to be done in X period of time. And certainly the timeline will vary on a number of factors. The complexity of the allegation. Certainly we've seen, matters that are, I won't say straightforward, but not being complex, an ADR being put in place in a shorter period of time, and whether or not an investigation is required. If the committee, the Complaints Authorization Committee, orders the ADR, they also have the ability to say investigate or ADR or both in accordance with the regulations. So if we're investigating, of course, we're getting that information up front, and that will certainly inform the alternative dispute resolution. And in matters that we're resolving where there is fitness and capacity issues, we may need to get medical documentation from the respondent's healthcare providers. And again, that can take some time to not only to request, but to receive the response back from the healthcare provider. Trudy, did you have any comment?
Just in terms of looking at the timelines for example, when an investigation is ordered. We've had instances where the investigation may take some time because some of the witnesses, for example, that the investigator needs to interview are away on vacation or not available. So those things can sometimes slow down the process. And of course, with medical documentation, in order to craft an agreement that needs to take someone's health needs into consideration, again, it's a circumstance where we're dependent, or the investigator is dependent upon getting that information from a third party, because if you're looking at medical documentation from a practitioner, then that may take some time, but it's the type of information that's required in order to put the type of terms and conditions that need to be put in place in order to protect the public.
Thank you, Trudy. The next slide, of course, once the agreement has been proposed, it's been reviewed by the nurse. The nurse agrees that what is proposed, yes, I'm willing to enter into this agreement. It goes to the complainant. They review it and see if they're willing to accept what is proposed as satisfactory to resolve the allegation. Then all parties sign on. If everybody is in agreement, all parties sign on. And then AR&L, through Director of Professional Conduct Review, monitors compliance of the respondent to complete what has been set out in the agreement. And I will tell you, in the agreement, it will specify the timelines to complete requirements. So if the requirement is to do the Code of Ethics module that's available online at CourtPark, it will state in the agreement that the nurse has, let's say, 1 month to complete that. So AR&L will be monitoring, and we will, as part of that agreement, we say, and you will give us certificates to say that you completed it. So we'll monitor all of the terms and conditions and get the nurse is required to submit the necessary documentation confirming that she or he is in compliance. And as I say, of course, the registrant is accountable to comply with all requirements, and failure to comply with an agreement made under Section 22 or Section 23 of the Registered Nurses Act would be conduct deserving of sanction and may lead to another allegation. But it's very specific in the agreement when and at what time period a nurse is to complete something. So, and remember that the nurse has had this information before him or her to review and determine if it was acceptable to them, and then they sign on to that agreement. So they're well aware of their accountability to comply with all of the requirements.
The only other piece that I'll add to the monitoring piece, from time to time we've had circumstances where the agreement was in place, there were timelines specified in the agreement, but it could be a circumstance where, for some unknown reason, at the time the agreement was entered into, and for some reason the nurse was not in a circumstance that they were actually able to comply with the timeline specified. And that could be anything from, life events to illness, tragedy, anything. And in those circumstances, the approach taken is to look at, the accountability of the nurse and coming forward saying, for this reason, I could not comply here. And in those circumstances, when the nurse is being accountable and can demonstrate, we've had circumstances where the agreement has been amended with the consent, of course, of all parties involved to look at extending the timeline, simply because it's a fair and reasonable thing to look at doing. We've had other circumstances where there is absolutely no excuse for failing to comply with the terms of the agreement. And it's been circumstances where Michelle has filed an allegation for breach of the agreement, and we've had circumstances where the complainant filed because they may have circumstances where there's an involved and the employer may come across more immediate information than the director would, and the employer has actually filed because there's been a breach of the agreement as well. So I point that out to you because, you know, from two perspectives. One, that there are mechanisms to reasonably address unforeseen circumstances, but as well that for individuals where they're, you know, are not really, I guess, being accountable and being responsible to the agreement and adhering to the terms of the agreement, that there are ramifications that flow from that as well. And, you know, we've certainly had circumstances where failure or breach of the agreement, we've ended up in a discipline hearing process. So registrants and complainants need to be aware of those factors because, you know, this is serious business, and individuals have to be accountable for their conduct.
Thank you, Trudy. And the last slide that we have before we go into a few questions is just in regards to resources for legal advice. Trudy?
Okay, anytime Michelle, as director, sends out an allegation, it's always with a document that identifies that, you know, a registrant is entitled to legal advice throughout this process, and that's important. She also shares with them information on the ARNNL Legal Assistance Plan, which is a plan that has been in place for quite some time to provide some assistance to cover some legal costs for registrants. I will say to you that that plan has been depleting very fast over the past couple of years, and it is something that Council will be reviewing at its next Council meeting to take a look at that, because monies coming in are being depleted. Less is coming in and more is going out. So pretty soon that fund will be depleted. So Council needs to look at that. The other area, of course, there through the CMPS, there is supplemental protection insurance that registrants can purchase to deal with professional matters, and it's our understanding that the nurses union as well may be of assistance in some circumstances to provide some legal guidance in that regard. So those are the three areas, and we put it out there because, and I'll be honest in saying to you, you know, anytime that when we're dealing with serious matters, it is important from our perspective that that registrants have legal advice along the way. Such legal advice expedites the process because they can engage legal counsel who can advise them exactly what the process is and what their rights are along the way. And because we are not in the business of giving legal advice to registrants, that's not our role. Our job here is to protect the public. But it is important for nurses to understand and know their rights, and procedurally and substantively in terms of what the law provides for in circumstances where a registrant has breached the standards or is incompetent or is engaged in professional misconduct in some way.